Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today we're talking about driving prohibitions and impaired driving. Cases that should have gone to the Supreme Court of Canada, but didn't. Karl Begin was convicted of driving with a blood alcohol concentration in excess of 80 milligrams of alcohol in 100 milliliters of blood and causing the death of another individual on the road. In sentencing him, the Quebec court that heard his case sentenced him to 6 years, 6 months in prison, plus a driving prohibition for 10 years with 5 years of ineligibility for an ignition interlock program. Mr. Begin appealed his sentence, not saying that the jail term was unreasonable, but saying that the length of the driving prohibition and the reasons behind the length of the driving prohibition were insufficient. And this is actually a very common issue that arises in courts with respect to driving prohibitions where Crown and defense are not joined in respect of the length of a driving prohibition. Judges often given very little in the way of reasons as to why a driving prohibition is going to be imposed for 10 years versus 5 years, for 2 years versus 1 year, or whatever length that they determine. The sufficiency of reasons is not necessarily a standalone ground of appeal, but can be in circumstances where the pathway to the ultimate decision made against the individual is not discernible such that a reviewing court can intervene. And so judges usually need to say something about why they're imposing a driving prohibition of a particular length, but often we just hear, I find that the driving prohibition, the appropriate length of a driving prohibition in this case is 6 years, and then leave it at that. But more analysis needs to be conducted on this, particularly for individuals who are significantly impacted by driving prohibitions, people whose line of work is driving. There are mandatory minimums under the criminal code, and departing from those mandatory minimums should require more justification than 1 or 2 sentences, given the significant impact that a driving prohibition can have on the life of an accused individual and their future opportunities for work and employment and engaging with their family obligations and volunteerism and all of the things that we want to encourage them after their involvement in the criminal justice system to participate in. So why should driving prohibitions and the length of those driving prohibitions not get the same consideration that you would see in a judgment in determining how long to sentence a person to for a period of custody? This is a significant issue. The Supreme Court of Canada should have explained at least, heard the case just to explain why judges shouldn't be required to give thorough and considered reasons to the imposition of a driving prohibition of a particular length in any type of driving offense. And unfortunately, the Supreme Court of Canada kind of just left it, seemingly implying that we can all just be satisfied that if a judge says a driving prohibition should be a particular length, then they don't really need to do more to explain it, even though sometimes the driving prohibition is the biggest sticking point for the accused individual. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.